So first up, as I said, is Holly Handler. She's been our attorney for quite a few years. And before that, she worked at Alaska Legal Services and partnered with us a lot in terms of our child welfare work. Holly also helped us with quite a few trainings that were really amazing. And so Gunnar Chish, thank you for sharing your presentation and your experience with us today.
Great, thank you, Will. And thanks everybody for being here on a beautiful summer day. And thanks to my team at TFYS who constantly educates me on all the great work they do in child welfare and about permanency options and why the tribe is so committed to connecting kids with their extended family. So I'm going to go ahead and screen share. Okay, hide that. So if you can bear with me for just a few minutes before I dig into the different categories of cultural adoption and tribal court adoption, I did want to place those two categories of adoptions in this larger framework of permanency options for children in child in need of aid cases. Particularly in Indian Child Welfare Act cases, which are all the cases that we deal with at Tlingit and Haida. So when we're thinking about permanency, we're always thinking about the whole array of permanency options for kids. And the number one permanency option that we think about at the very beginning of the case and that we keep thinking about throughout the case, which is our goal, to state law and ICWA and federal law. And then just from the perspective of kids, we're always trying to keep first and foremost the idea of reunification in our mind. And this applies to all the kids' parents that are alive at the time that the child in need of a case starts. So it's somewhat common for parents to be split up when a child is born or when a child comes into custody. And the Office of Children's Services has an obligation to consider reunification with both parents, even if one parent hasn't been a caregiver. And that's true even if older kids haven't known their parents for a long time. The Office of Children's Services works to try and develop a relationship with the kids and both their parents to the extent that that is safe. So when we talk about permanency, we're always starting the discussion with reunification. And then before we start thinking about adoption, we are thinking about culturally appropriate permanency options. And those typically are guardianships. And the reason, and I don't want to step on the toes of the next presentation, but the reason that we think about guardianship before we think about adoption is that adoption almost always involves the termination of parental rights. And when that court order is issued, that court order not only terminates the legal relationship between the parent and the child, it also severs the child's relationship with their extended family legally. It could be that relationships continue, that there's open adoptions or open guardianships, but legally, that child no longer has their grandma as grandma, their uncle as uncle, their aunt as aunt, and cousins as cousins. And that can have lifelong effects on kids that come out of custody. So there's also other reasons, but really guardianship, first and foremost, serves to preserve extended family ties for kids, even when kids are not going to go back and live with the parent, when they're going to stay in an out-of-home placement for the rest of their childhood. So guardianship can be done through tribal court. Tlingit and Haida has a full-time tribal court operating in our Juneau building downtown. And that tribal court serves tribal citizens in different parts of the state. There's also guardianship that can happen through the state court. Those two processes are somewhat similar in which notices go out, the hearing is held, there's an investigation done, and if the kids have been in a licensed foster placement, they're eligible for a subsidized guardianship, whether that guardianship is finalized in tribal court or it's finalized in state court. One last thing about tribal court guardianships is Lincoln Heights is certainly not the only tribal court in the state of Alaska. There are 229 federally recognized tribes in the state of Alaska, and many of those tribes operate a tribal court that can conduct guardianship hearings. If anybody's interested in more information about tribal courts, alaskatribes.org is got a library of information about tribal courts, including the latest version of Alaska Legal Services Tribal Court Directory for the state of Alaska. So typically for Tlingit Haida cases, after looking at reunification and looking at options for guardianships, there are times when the tribe will consider adoption in certain circumstances that the next presentation will cover a little bit more. But if adoption is going to be pursued as the permanency option for kids, there's 3 different ways that can happen. So there's a tribal court adoption, a customary tribal adoption, or a state court adoption. Like guardianship, the processes look somewhat similar, where notices go out, there's a hearing or a meeting that's held, evidence is taken about the appropriateness of the adoption. There can be a home study if it's going to be a subsidized adoption. And then the adoption can be either open or it can be closed, meaning there can be retained rights of the parents and there can be options for visitation if that's safe, or it can be closed. The presentation topic today is about the difference between tribal court adoptions and customary tribal adoptions, because that can be really confusing. You know, why are there 2 kinds of tribal adoptions and what is the difference? So I'll get into that in a second, but I did want to cover, there are a couple other options for permanency. One is very rarely used, and that's third-party custody. So just like a mom and a dad can get a custody order for a child if they're not living together, third parties, grandparents, aunts, uncles, other relatives can also get custody orders for kids in either tribal court or state court. It works a lot like a guardianship. It's not a recognized permanency option in the child welfare system because there's no reporting requirements afterwards, and there's nothing like a final adoption order. It's just a custody order. So you can't get a subsidy with a third-party custody order. And the mechanism of achieving it is a little tricky, where the custody order goes through and then OCS would have to agree to close the case based on that third-party custody order. Anyways, it's a rarely used option because there are a lot of tricks to it, but I just did want to recognize that that it is a possibility for cases to close with the third-party custody order as opposed to guardianship or adoption order. Finally, it's covered by my little bar here, but some kids do age out of foster care without any of these options actually going through. There's also APLA, another planned permanency living arrangement, or a long-term relative placement that is not custody, guardianship, or adoption. I did want to highlight a bit for our presentation this difference between tribal court and customary tribal adoptions. So a tribal court adoption looks a lot like a state court adoption. It's done through a tribal court with a judge through a hearing process with notice to the parties. OCS will cover the cost of an attorney to file the paperwork in tribal court, just like it covers the cost of filing paperwork in state court if it's a subsidized adoption. And the adoption order often looks a lot like a state court adoption, whether it's done in tribal court or state court. Customary tribal adoption is done through resolution of the tribal council. There is a state of Alaska customary tribal adoption packet, and a few other states have similar packets. And it is a series of forms that a tribal council will fill out to approve a customary tribal adoption. And then the effect of the resolution operates in the same way that a state court adoption or tribal court adoption order would operate. The history of the customary tribal adoption in Alaska kind of explains why there's this weird discrepancy. Why do we even have these 2 systems? And that stems from a time when we did not have formal legal tribal recognition in the state of Alaska. There was many decades where the state of Alaska advocated very strongly that tribes don't have jurisdiction in Alaska to hear domestic relations cases, which created a lot of complications in the child and native aid world. And sort of as a middle ground of accepting tribes being able to decide on their own adoptions, the state of Alaska created this tribal council process and set of forms for tribal councils to follow to recognize tribal adoptions. Now, after many decades of litigation, and now that we have things like the formal recognition of tribes in Alaska through legislation, the state of Alaska will consider customary tribal adoption resolutions and tribal court adoption orders as the same thing in essence. Any questions before I go on?
I guess I'll ask one. I don't really know how to articulate it perfectly, but who in the case decides which type of adoption will be done in a particular case, and whose weight holds the most weight, whose words hold the most weight regarding that?
That is a great question. Thank you for asking that. So the permanency process, I'm sure other people will talk about too, is not a one person decides process. It really is a team effort. So it typically starts with a permanency planning committee, at least in our Southeast cases, where the parties will come together and try to reach a consensus on what permanency option is going to serve the kids in the case with all their particular needs and circumstances, whether the team is going to keep focusing on reunification as the primary goal or look to guardianship or adoption or some other permanency. And so that usually starts the discussion on permanency. And then ultimately the court, whether it's a tribal court or state court case, the court is going to be the entity that decides on the approved permanency goal for the children. If we get into the third stage where we're actually pursuing a guardianship or pursuing an adoption, the custodial parent or parents are really going to be in the driver's seat because they're the ones that are going to have to file the petition for guardianship or for adoption. So typically we'll try to provide a lot of information and resources and opportunities for meeting with the OCS and ICWA worker together. And if there's an attorney involved, a guardianship or adoption attorney, typically we'll try to meet all together and talk about what it's like to file in tribal court, what it's like to file in state court, but then the custodial, the foster parent will be the person deciding where to file the petition and what kind of petition. Does that answer your question?
It does. Thank you so much.
Okay.
I've got a question. This is Natalie
Hi, Natalie.
with OCS in Anchorage. Hi, it's nice to see your face, Holly. I don't know if I ever have, but we've been on the phone together. Does the tribe have to have assumed jurisdiction in order to file or resolve a permanency matter in the tribal court?
Another great question. Thank you for asking that. So no, it happens fairly commonly that there'll be a state court child in need of aid case going on, and then the parties will confer about permanency options and then decide where the foster parent wants to file. And so often in our cases, the state court China case will be going on, and then there'll be the guardianship or adoption case filed in our tribal court. Brooke Tass at the Office of Children's Services has been totally wonderful to work with. She's helped us coordinate in other cases about making sure the timing is right for the subsidies for the guardianship case to go through and making sure that everything on the subsidy end is taken care of and negotiated before the guardianship or adoption order is signed. And then making sure we've got clear lines of communication, that they get a copy of the final order from the tribal court, and notification about when the hearings are. And then once they get that final order, then the state court closes its case and the subsidy starts flowing from the state.
Thank you.
Thank you, Natalie. Other questions?
We have a couple of in the chat box. A couple of questions. Would you like me to read them to you?
I can try to open the chat box. Let's see. From David. How is guardianship different from an Indian custodian?
And there's one right above it as well from Brittany.
Okay.
Thank you.
Sure. So an Indian custodian is a non-parent who's taking care of a child before any foster care child in need of aid case is opened. So ICWA recognizes Indian custodians, basically put them in the shoes of parents if OCS removes a child from someone who's not a parent. So it could be that they're caring for a child because they're a legal guardian of the child. It could be that they're caring for the child with a power of attorney, or often the case, they're just informally caring for their grandchild or niece or nephew or cousin, just because that's what families do, is take care of each other.
Holly, we have another question that I got in direct message.
Okay.
Is there still a termination of parental rights for both tribal court and cultural adoption? And are they done through tribal court and resolution respectively?
All right, that's a great question. And that one's a little tricky to answer. It's because it's a complicated answer. So under Tlingit and Haida's tribal code, it is not necessarily the case that adoption will terminate all parental rights. So there can be cases where, like the state system, parental rights will be terminated and then an adoption will go through in tribal court. It could be the case that there's one parent whose rights have been terminated and then another parent that has retained, whose rights haven't been terminated. An adoption can go through to add another parent for the child, in a sense to replace the rights of the parent who's been terminated. And so there's more flexibility under tribal code to retain the rights of one parent while the adoption goes through. It doesn't necessarily terminate all pre-existing parental rights. And we actually consider that in one case where there is an incarcerated dad, and there was an adoptive mom, and they, were considering that adoption arrangement so that this child would still have a relationship with their dad, even though the dad couldn't take care of her, but there'd be a new adoptive mom so that she could have a legal custodian who could take care of her day-to-day needs. Are there more questions in the chat?
Yes, there was another one. How is guardianship different from Indian custodian?
Okay, I think we covered that.
We already covered that one, sorry.
Custodian is really before cases started. Yeah.
Gotcha. And then a comment. My experience is that the family still has to be licensed by OCS if the tribe does not make jurisdiction. Sometimes that is a reason for transfer. Has that, I guess, been your experience?
I can explain that because it looks like maybe it didn't.
Oh, hey, JP.
Hi. I'll often encourage tribes to take jurisdiction for family members, or a couple different reasons. One, for family members who do not want to be licensed by OCS. And what I've been instructed is that they can't be adopted while they're in OCS custody by a non-family member who is not licensed. And then the other is a placement where OCS can't place because of barriers, but a tribe could. I will encourage a tribe to take jurisdiction so that they can do what they feel is best. And oftentimes what I feel is best too, but I can't do it.
Mm-hmm. Yeah, with 229 tribes in the state of Alaska, there's a variation of tribal codes in terms of whether they're more flexible or less flexible than the state system. But yeah, it is a really amazing and wonderful thing in the state of Alaska that we have different systems to meet kids' needs, because kids' needs are so different and so unique. And so one of the interesting things about this permanency process is it looks so different for every kid. And having options for ICWA cases is really exciting to figure out how can we be creative and think outside the box to meet kids' needs. So thanks for raising that, JP. Anything else before I move on?
I don't see any other.
Okay.
Oh, here's a question actually.
Okay.
Just popped up. With family being preserved, why would guardianship for a 3-year-old be better than adoption with a relative, with the parental rights terminated if the parents are not showing that they're willing to be safe parents? This looks like a very case-specific question, but I don't want to editorialize too much.
So actually, maybe that's a good segue into the next page here. So just as a preface, I think I just mentioned, like, every case is so different. And so there's no, whether we're talking about the state laws or tribal policy or tribal code, there isn't a one size fits all blanket rules that cover every situation. The next presentation is going to do a deeper dive into this, but generally, why we have guardianship above adoption in our chart is really doesn't have much to do with age, and it really doesn't have to do with the expectation about the parents stepping up to resume their caregiver duties. Guardianship is more consistent with an Indigenous way of life, and that it recognizes that kids can have caretakers who raise them, who are not necessarily parents, but mom is still mom and dad is still dad, and the relative raising them is still the relative or other caregiver. There typically is not termination of parental rights with guardianship. Guardianship can occur without that having to happen legally. There are instances where our team will support adoption in some cases. In the next presentation, we'll go into that a little bit more if there's a clear preference from the child, if there's a relative who's been through the system or has a clear understanding and knowledge of the process and has made a knowing decision that adoption is what they want to pursue. Sometimes there's a financial need, and there's benefits in some states outside Alaska that give a lot higher level of benefits for adoption over guardianship. And sometimes there's a parent who's a real danger to a child's life or safety, where there needs to be some more very clear boundaries. And I just want to say that this isn't just something that the tribe has come up. There's a lot of national research from policy organizations, and the Attorney General's office at the state of Alaska their position has evolved significantly. And so in their presentations from their head attorney at our court improvement project meetings, they will talk about how guardianship really has become an equally valuable permanency option with adoption for not just tribal kids, but for kids all over the state. What the research has shown is that by and large, permanency tends to last through the child's 18th birthday, just as an adoption would last through the child's 18th birthday. And that's not because there's no possibility of a parent asking to come back to court, but the standard for a guardianship to be overturned is extremely high. And it's just very rare that that happens. Okay. Step back into the definition, to the differences between the cultural adoption through tribal councils and tribal court adoption orders, just breaking down a little bit what the differences look like. So the cultural adoption is approved by the council, so the governing executive body of the tribal government, as opposed to a court. Whereas the tribal court adoption order, of course, is by a court. One small little asterisk there is that in some tribes, particularly some very small tribes, their governing documents authorize their council to serve as the judicial authority, as the court. So the council in some tribes, in some tribal governments, may issue orders through their council as opposed to a separate court. There are the same due process elements, also known as fair procedures, whether an adoption is going through the tribal council or going through the tribal court. There's tribal codes that may be written or unwritten. There's a hearing or a meeting set in advance with notice to the relevant family members about the adoption. There is a chance to be heard either by the council or the court, and for any interested party to present evidence either in support of or against the adoption. And then there is a decision based on the facts. As far as notice, the cultural adoption packet has consent forms for the parents to sign. So the cultural adoption process is really for uncontested adoptions. For tribal courts, there's a broader scope of cases they can consider. The parents do not necessarily need to sign a consent to adoption, just like state court. There could be a contested hearing in tribal court. The parents would have notice of the hearing, they'd have a chance to participate, and then a decision would be made, based on the council or based on the court weighing the evidence presented. What's produced at the end from the council is just a pre-printed form that's filled out that goes to vital statistics, as opposed to tribal court order, which typically looks like a lot like a state court order for resolution. And at the very end of the process, there's a little bit of difference in forms that get sent to vital statistics. The cultural adoption packet has a packet and then a fee that gets sent to vital statistics to get a new birth certificate. For the order, there's a different form, a certified copy of the order plus a request for substitute birth certificate gets sent in that case. And this is just an example. This is what a typical tribal court adoption order will look like. It has the case caption. It has some basic information about the parents who got notice of the hearing, when the notice occurred, and who attended the hearing. There's findings that are made. Typically, there's a home study, just like there is in the state system. And then there's a final adoption order. In contrast, the cultural adoption packet from the state of Alaska looks more like a bureaucratic pre-printed form. There's fill in the blanks for the PDF, and that gets submitted to vital statistics at the end of the case. So I'll stop screen sharing. And yeah, leave it up to any questions, any comments.
We have another question. With tribal guardianship, are parents required to continue paying child support?
Guardianship typically preserves a child's right to financial support from their parents. So yes. child support would typically, of course, every case is different. And, you know, there are exceptions to the rule where continued child support is not ordered, but typically child support will continue.
If we're working with a tribe and they'd like to pursue one of these options, but don't feel equipped or have the information they need to do that, can we point them to a resource that will help walk them through it?
In terms of pursuing tribal court?
Yeah, because I've had 2 different tribes I've worked with that have really requested a lot of hand-holding, for lack of a better word, to go through the process, and sometimes it's really difficult.
Sure, yeah, and the experience is going to be different depending on how each tribe in the state is set up and their resources and availability. You know, the ICWA worker is going to be the best resource between you know, the state system and the tribal court. Alaska Native Justice Center is a great resource for providing help to tribal courts and tribal councils in terms of managing domestic relations cases. There's also been a lot of tribes who have been assisted by Alaska Legal Services in terms of walking them through the process of an adoption or guardianship case.
Perfect, thank you.
Mm-hmm. And sometimes, you know, for whatever reason is happening at the tribe, it's not always an option to do a tribal guardianship or adoption. For some very small tribes, because, well, just to step back, because of our system of lands in Alaska, you know, tribes in the lower 48 have tribal lands that generate a lot of financial resources for tribes. Because of our land claim settlement in Alaska, most tribes in Alaska do not have a significant land base. So what that means for our day-to-day practice is that judges are often volunteer judges. Clerks may be a part-time clerk with 20 other duties. So tribal resources to operate a justice system can be taxed pretty heavily. So there's going to be a lot of variation in capacity to do these domestic relations cases full time.
Thanks. That's actually a really helpful perspective to have when working with the tribes, that ANCSA is a little different than the reservations when it comes to financial resources.
Thanks for your patience with my long-winded answer.
Holly, we have one more question before we close out our time.
Okay.
Do adoptive parents need to be tribal citizens to do a tribal adoption?
A great question. So no, adoptive parents do not need to be citizens. The tribe's jurisdiction over cases turns on the citizenship of children. So if kids are eligible or enrolled citizens of the tribe, that would give the tribal court or council jurisdiction to conduct that guardianship or adoption case. Thank you for that.